Let me see. Oh my God, how do I do? All right, give us a minute. We're going to be. All right, everyone, welcome. It's wonderful to have you guys here with us. I'm going to start our presentation, and here we go. I was giving a few minutes to have everyone kind of join us. I know we had about almost 80 people register for today's webinar. I know sometimes people get a little bit tied up, so I was just giving a few minutes, but I also want to respect the time of everyone that did show up on time, so thank you very much. And so we're going to get started, and as people join, they can join us in the presentation. So we are at the beginning of the year. January is almost over, and one of the most important things that always comes to mind, at least for me being a real estate attorney with the beginning of a year, is it's homestead application time. It's homestead exemption time. So I thought it was a perfect time and opportunity to go ahead and do this presentation on the homestead tax exemption, how to figure out different information about it. What is it? Does it apply to me? What do I have to do? And also the portability. If you last year purchased a property and are now sold the property and purchased a new one, how to port your homestead exemption and all of that. And as well, we're going to discuss a little bit of estate planning tips that apply specifically to homestead properties to help protect your most valuable possession here in the state of Florida. All right, so with that being said, a little bit about me. If you guys don't know who I am, my name is Alina Nuñez. I am a real estate attorney, estate planning, and probate law. Those are the three areas of my practice that I focus on. I have been an attorney for over 22 years, and I've had my own practice for the last 11 years. So I have a lot of experience, a lot of different situations I dealt with over the years regarding real estate property, estate planning, and people who didn't do their estate planning and then have to force and go through the probate process. So all of this is all intertwined because typically when it comes to our estate, our biggest asset is our homestead property, our primary residence. So that's going to be our focus and what we're going to be talking about today. I did graduate locally from Nova Southeastern from law school here, and I am a Miami girl, born and raised. So what exactly is a homestead property? And when I refer to homestead, I'm not referring to the city down south, no disrespect to the city of Homestead, but here in when we talk about the homestead property, we are referring to your primary residence. So a homestead property in the state of Florida is defined as your primary residence, and there are certain protections that are built into our state's constitution specifically for that homestead property. So another thing we're going to be talking about as we go through the presentation is it's not just the tax benefit that you receive where we have our homestead exemption, but it's also there's additional protections in regards to your homestead property that are very important to know. Okay, so the Florida homestead protection applies only to natural persons in their principal residence. So you cannot be a corporation and claim homestead exemption on your property. Even if you live in it, you can't. It has to be in your individual name, and you need to reside in it as your primary residence. If it's not a property that you reside in as your primary residence, it does not have the qualifications to be your homestead property. Oh, and I forgot to mention at the beginning, if you have any questions, we're going to go through a lot of information. I know it's going to be a lot of, please put them in the chat. And at the end, I will do my best if we have time to go through and try to answer every single question versus stopping in the middle of the presentation. So if you have any questions, please feel free as we go along, put them in the chat. And when I'm done, I will go back through and try to answer all the questions as best possible in the time that we have. So what are the requirements for a property to be considered your homestead property? So as I mentioned already, the property has to be owned by you individually, or it can be owned by your revocable trust. Okay. So for my clients that I do estate planning for, when we transfer the title of their property from their individual names to the trust, one of the first things I assure them is you are not going to lose your homestead exemption. This will not affect your taxes. If it's your trust, you transfer the property into your trust, you're still able to retain your homestead exemption on that. But you cannot claim homestead if it's in the name of an LLC or another type of corporation. It has to be in an individual name. The property must be your primary residence. So you have to live in the property as your primary residence. That means at least 50% of the time of the year. Otherwise, you cannot claim homestead exemption. It has to be in the state of Florida. So we're dealing with any property in the state of Florida. And the property, like I said, has to be occupied as your permanent residence. Also, it needs to be, there's certain requirements regarding the size. So the property cannot be any more than half an acre within a city, or it cannot be more than 160 acres outside of a city. So if you own property, let's say somewhere like Central Florida, where there's much bigger, land, and you have your home and you own, 20 acres, all those 20 acres with that home, the land will all be protected and fall under that homestead protection. Now, conversely, let's say you live here within Miami and you own a property and it's an acre and a half. Well, there's going to be, you can still claim your homestead exemption, but only an acre of that property is going to be protected if there are any creditor claims against you. And we're going to talk about that. That's one of the protections that the homestead gives you against creditor claims, and we will address those further in the presentation. But there is a size requirement besides it being a property and besides it being your primary residence in your individual name, there is a size requirement. Okay. And the property must be contiguous, meaning it has to share a common border. You can't have, let's say, a property here, and then maybe there's like a small little lot in the middle, and then you own the property on the other side of it. No, it needs to be one continuous parcel. There can't be any division of that parcel where maybe there's like a road that goes through it or something. It would then break that. Okay. So basic homestead is best described when a person owns real property, it's your permanent residence, and you can receive a property tax exemption of up to $50,000. So when you apply for your homestead exemption, you have your basic $25,000, and then you can qualify and receive an additional $25,000. So you have a $50,000 tax exemption. That is one of the benefits with the homestead, is that tax exemption. And we're going to talk about what that looks like. Is it $50,000 that you're getting from the county or the state? No. It's being reduced from the value of your house of what you are taxed on. Okay. And we have some examples with calculations so you can kind of better understand of what that looks like with that 50,000. Because a lot of people, that confuses them, like, oh, okay, so I'm only going to pay 50,000 or I'm going to get 50,000. How does that work? And we'll explain that for you. But that is the tax benefit. It gives you a break or a deduction on the amount that you pay on property taxes based on the value of your home when you have that homestead exemption. Where if you do not have homestead exemption, let's say it's an investment property, you cannot receive that credit. Okay. The Save Our Homes program. This might be something also, especially if you're in the real estate industry. I see we have a lot of realtors with us today. That's wonderful. Maybe you've heard of what exactly is the Save Our Homes. Maybe you've heard of the terminology. So this is, again, another kind of incentive for your property taxes, okay, under the homestead. So it's a benefit that limits the increase in the annual assessment or the annual taxes of a home to no more than 3% or the CPI, the Consumer Price Index, whichever is less. So any property owner with a homestead exemption will automatically receive this additional benefit. So what does this mean, especially to my realtors that are here with us today? When you're showing properties to a potential buyer, and let's say this seller has owned this property for the last 20 years. They bought the property back in, let's say, 2004, and now they're selling it, and their property taxes, let's say they pay $3,000 or $4,000 a year on their taxes for the property. Well, any new buyer that's going to be coming in, and now this house is worth, considering how the market is in Miami nowadays, it's probably worth $1 million because here it feels like everything is here worth $1 million, which obviously would pay much higher taxes. So now this buyer's like, great, my taxes every year on this house is only going to be $3,000 or $4,000. That is not correct, because this owner, this seller, has had this Save Our Home benefit on the property for the last 20 years. So when they purchased that property back in, let's say, 2004, 2005, they applied for their homestead exemption, and they had that 3% cap that their taxes could not increase year after year, regardless of how the value of the house increased. So that's a big thing that I see very often, where we will do a closing for a client and they think that, okay, these are the taxes I'm going to pay on my house. And when the end of the year comes and the closing already took place, they're the new buyers, and all of a sudden they get their new tax bill, because the tax bills here come out at the end of the year for the year that you lived the property. So if you purchased the property, let's say January of 2025, you're not going to get, as a buyer, you're not going to get your tax bill until November of 2025 for this year. But by the time that November comes around, the tax collector has already in their system, they see, oh, Alina bought this property from Mr. and Mrs. Smith, and she bought it for $1 million. So, okay, we're going to now reassess the property. We're going to adjust the taxes because Mr. and Mrs. Smith don't own this property anymore. And we're going to bring up the taxes to whatever the current value of what Alina bought the property on, and apply whatever exemptions I qualify for. That's going to increase property taxes because Mr. and Mrs. Smith has had that 3% year after year. And once they sell, that goes away. So that's a big question or big phone call that I get the following year with people screaming, going, why are my taxes so high? Well, because you're not paying Mr. and Mrs. Smith's taxes at their value, you're paying it at your new value. And in fact, most realtors, if you haven't noticed, in the last couple of years, when they've made revisions to the FAR bar contract, they have added it to the contract, and it's in bold that says, it's kind of like a buyer beware, letting you know, do not rely on your current seller's taxes. Taxes will be reassessed once the property is sold, because that became a big issue. So with your realtors, please make sure, if that's a situation where you're selling or your buyer's interested in a property that this owner has owned for many years, and it has that Save Our Homes cap, and it's had it for the last, X number of years, please make sure that your buyers understand their taxes will go up. Okay. So then additional benefits for qualified homestead properties. We talked about the homestead exemption, that you get the $50,000 exemption. And in fact, at this most recent election, there was a bill on the ballot that ended up passing that is going to now change or increase that 50,000 depending on how the values increase in the future. So once that goes into effect and goes through legislation and gets final approved and starts applying, that $50,000 of homestead exemption, which was established many years ago when the cost of living was substantially less, the cost of property taxes and property values were substantially less. It's never grown with our standard of living, and it's never grown with what has changed. So you can't say, it's unfair to say, okay, you're going to get $50,000. Yeah, but houses used to be worth 150, 200,000. We're not there anymore. $50,000 credit on $1 million house, it's peanuts. So it has to adapt. And we voted on it. It was voted on and approved, and it's going through its process. So that'll go into effect. But as of right now, we have the 50,000. There's a couple of additional exemptions that you can qualify for. Senior citizen exemption has to meet certain age requirements, certain income requirements. You can apply for those in addition to your homestead. Widow exemption. If you have someone that recently, they lost their husband or their wife, and they're going to remain living in the house, they can now apply for an additional widow exemption, which I believe is an extra $5,000. The senior citizen, I believe, is an additional $500 exemption. There's civilian disability, veteran disability, deployed military. These are all additional exemptions that you can qualify for and receive additional credits off of what you're going to pay taxes on. So with my probate clients, anytime I'm handling an estate, I definitely tell them, make sure you apply for your widow exemption so you can qualify and get that additional exemption, because any little bit, any little reduction of what you're going to pay for taxes helps. Okay. But in order to qualify, you do need to fill out the applications online with the county, provide whatever documentations they're going to need. So to make sure that you do qualify those, and then they will add those in addition to your homestead exemption. And again, going back to that point of buyers who are buying properties, if you're buying properties, I've seen it where an elderly person pays very little in property taxes, like $1,000. It's because they have the homestead exemption. They've had that Save Our Homes for many years. They have also the widow exemption. They have the senior exemption, and I've even had some that have the veteran exemption. So all of those keep their property taxes very low. But again, a new buyer cannot rely on that. They have to apply for whatever exemptions they're going to qualify for. Okay, those you cannot kind of inherit from a previous owner. So what is portability? So portability applies when you own a home that you already claim your homestead exemption on, and you are going to sell that home and buy a new home. You're going to port your exemptions from that previous homestead property to your new homestead property. And the county, depending on whether you're going from a less expensive to a more expensive home or the other way around, and how long you've had the homestead at your existing home, the county gives you a certain additional discount or an additional reduction on the assessed value that you're going to pay new taxes on the new home. Okay, so this does not apply to any homeowner who is buying their primary home for the first time. So if you have someone that, let's say, maybe they rented for many years, and then now they're deciding, okay, I'm ready to buy my own home, they are not eligible for portability because they've never claimed homestead anywhere. This is only eligible for people who previously claimed homestead, and they're porting that homestead to a new property. They're selling that one and they're buying another one. Then you would qualify for that portability. So portability, or the transfer of the homestead assessment difference, is the transfer of the Save Our Home assessments, that 3% cap that we had, right? From your previous homestead to your new homestead, but up to no more than $500,000. That's why it matters if you're going from a less expensive to a more expensive, then you can maximize that portability. Or if you're going from a more expensive and you're downsizing, let's say someone who's looking to retire or something like that, then you're going to still be able to get a portability, but it's going to be less because you're downsizing in value of property. So it can lower the assessed value of that new homestead. And to qualify, you have to fill out a specific form, at the time that you apply for your homestead on that new house. And when you do the application for the homestead, it'll ask you, one of the questions that it asks you is, did you previously claim homestead exemption on another home? Yes or no? If you did, then it's going to ask you some additional questions from where you're porting that homestead. It's very easy. It's not complicated. And they do the calculations themselves. They're going to ask you, okay, well, how much did you sell your home for? What did you buy the new home for? They're going to ask you for the property address so they can verify you did in fact previously own that home. But if you didn't and you answer no, then the portability doesn't apply to you. And then you just move on with the other parts of the application. So here is an example of calculating the portability when it comes to properties. Okay, so here we have a prior home of the home that you had that was $250,000. That home that you had that was $250,000. Now the new home you're buying has a value of $400,000. So you have a Save Our Homes assessment difference of $100,000. So you can transfer or port that full $100,000. If you had, so because you're going up in value, so you're going to be able to take advantage of that full amount. So if you had a previous market value of $250,000 minus the $100,000, then what you're going to pay taxes on is only $150,000 on the old house. And you get that same credit on the new home of your full port because you're going from a less expensive to a more expensive home. Now, if you are going to go downsizing, so your current home is $250,000, you have that Save Our Home assessment difference of $100,000, then you're buying a cheaper home of $150,000, you're not going to be able to receive that full $100,000 because you're downsizing. So they're going to do it based on the difference. So you're going to receive here a port or a reduction of only $60,000. So on your prior home, you were assessed paying taxes on a value of $150,000. On the new home, you're still going to pay taxes on a lower assessed value of $90,000. Okay. So step one, you take your previous home, you divide it by the previous market. That gives you what your ratio is. That's how they determine what your cap is. And then step two is you take that cap and you multiply it by the new market value. And that's how we got the $60,000. Again, this is not for you to calculate. I don't expect any of you to sit out there and be calculating this. This is how the county calculates it. I just want you to have an understanding and see how this portability works, whether you're going from a less expensive to a more expensive or from a more expensive downsizing to a less expensive home. Okay, so that gives you the two examples of how that portion of your Save Our Homes assessment travels with you when you're porting it to the new property. So in order to obtain the tax exemption, as I mentioned, you must hold legal or equitable title to the property. So you have to be on the deed. So if you are in a situation where, let's say, you live with your adult parents and your parents are the ones that are on the title to the house, but you live there, like, but I live here, this is my primary residence. It does not matter. You're not going to be able to claim that homestead exemption. You must be a legal owner on the title to the house. The property must be the permanent residence of the owner, and the realty has to be held as what we call tenants in common, or you have to, if you own it more than with one person, you have to own it jointly. Okay. Only one exemption per individual or family unit applies to the property. So you don't have to be, so it's not like you can get 50,000 and your husband can get 50,000. And if your son's on the title, he gets 50,000. No, it's one exemption per family unit on the property. Citizenship and exemption. This is a big thing here in Miami. We are, a very international city. We have a lot of people that come here from other countries. They buy properties that either they're foreigners or maybe they're still in the process of becoming a citizen. Maybe they're a resident. And I get that question a lot. Can I claim my homestead exemption if I am not a citizen? And the answer to that is yes, but it also depends on your legal status here in the country. So citizenship is not a prerequisite to obtaining the homestead tax exemption. Okay, in cases where the owner is a foreign national, but his natural or legal dependents are U.S. citizens and permanently reside in the home, then the exemption will be available. So only U.S. citizens, permanent resident aliens, or someone holding a permanent residence under control, color of law, a PRUCOL, is eligible for a homestead exemption. So if you're still here, like let's say on a visa, an L visa, an investor visa, and you're in the process of getting your legal status here, getting your residency, you would not be able to qualify because those are all considered temporary status. And if you're here temporary, you can't claim it your homestead because it's considered your permanent residence. So you do have to be a permanent resident, but you do not have to be a U.S. citizen to be able to qualify for the homestead exemption. So when to seek the exemption? Well, like I mentioned at the beginning of our presentation, I always tell people when they close January 1st, Happy New Year, file your homestead exemption. So the application process for filing your homestead exemption begins January 1st of the next year from when you purchase your home, and it closes by March 1st. So you have that time frame, which is right now, which is why I wanted to give this presentation, to get your homestead application in and get it and apply for it. After March 1st, they will not take your applications. You can try to petition and try to see if they would, but good luck with that. Also, if you closed and purchased your home at the beginning of this year, let's say you purchased it now in January, and you're like, oh, okay, great, I'm in the window of being able to apply. Unfortunately, you cannot. Because when you apply to the homestead, you're stating that you're going to reside, you have at least resided in that property as your permanent residence. And if you just purchased it, you haven't been able to establish that yet. So you apply for your homestead application, you put in your application for the year following when you purchased the house. So anybody that purchased a property as their primary residence in 2024, now is when they would submit their applications for homestead exemption. In fact, that's one of the things that we've done this year is we have called every single client of ours that closed on their purchases last year. And the first couple of weeks in the new year, we use that as a way to touch base with them, wish them a happy new year, and remind them, don't forget to apply for your homestead exemption. Because if they closed in February of 2024, they probably forgot, oh, that's right, I got to do this in January of 2025. So for all you realtors, there's a great opportunity for you guys to touch base with past clients that you did deals for them last year. It's a great way for you to, keep top of mind and add value to them. Show them that you care, that even though that closing took place last year, you are still there. They're still on the top of your mind, and you're there to remind them to take advantage of this homestead exemption and save them money. So you're welcome. That's what we do for our clients. But yes, so anybody that closes now in 2025 will then apply January 1st of 2026 for the homestead exemption. So in order to apply, you have to have resided on the property or have at least closed by the end of that year. So even if the closing took place December 31st of 2024, you would qualify to be able to apply as of January 1st, 2025. And you have to make your application. I mentioned March 1st, that's the deadline. I put here the two links for Miami-Dade County and Broward County. Those are the counties that we work with the most. Every county has their own application. You can just Google it. It's very easy. It's typically through the property appraiser's website or through the tax collector's website for that county. So if you're in Monroe County, Lee County, Collier, Hillsborough, any of them, the entire state of Florida, you can qualify and apply for your homestead exemption in the county where the property is located and that you reside. So these are Miami-Dade and Broward. And like I mentioned, it's a very easy process. When you go through, it'll take you step by step with the application. Here I gave you, and this actually I went on recently, and now they've kind of changed a little bit the way it is. This was how it was as of last year. Now I think they make you sign in and you have to create like a profile to be able to get to this page, but this should be what it still kind of looks like. It's very user friendly. It'll take you step by step of everything that you need and the information that you need to put in. Very important to know, in order to apply, you have to have already your driver's license with the address of the property, and which in turn will also change your voter's registration. You're going to need a copy of the recorded deed. So if you did not receive it at the time of the closing, or your title company didn't give you a copy, bad on them. Reach out to them, ask them. I always give copies to my clients. And I also, once it's been recorded, we send the originals because they're going to want to see and be able to show what date you took title to that property to make sure you're the owner and that you would be able to qualify for the homestead exemption. Everything else is pretty much information that you should know: your social security, date of birth, marital status, your driver's license. Like I mentioned, you are going to have to upload a picture. So that's why it's very important to make sure you have your address changed on your driver's license, so you don't have any issues, because they will kick it back and they will show that it was rejected because you didn't have your driver's license. I've had that happen to several clients, especially the ones that close like at the end of the year and they don't have time, or they haven't had time to change it. I've had that happen. It's not, you can still go back and provide them the proof, and your application basically stays on hold. So you're within that deadline. You met that deadline of March 1st, but it's kind of on hold until you upload the driver's license, and then they'll continue processing and approve it. So just make sure to avoid that. Make sure you have everything already with the new property address showing up. Okay. So what if I get divorced? This is also another common question that we get with, well, my husband and I claimed homestead exemption as husband and wife on this house, and now we got divorced and my husband left. He took him off the title. He signed over the title to me, and I'm the only one on title. So what happens to his homestead exemption, or what happens to our homestead exemption that we filed as husband and wife? Because remember, family unit is considered, the husband and wife, if you take title together, is considered a family unit. So in Florida, a family unit can only benefit from one homestead tax exemption, even if the spouses own separate residences individually. The exception to this is if you are in a divorce, truly separated. Here, the state of Florida does not recognize separation as a marital status. Divorced is divorced until you don't have that final decree signed off by the judge. You are still legally married. But if you have that decree and that spouse leaves, transfers his ownership of the title to you, and he buys his own property, he is going to be able to apply for his own homestead, even though he had homesteaded with you on this property, because there is a final judgment of dissolution of marriage that he can prove why, when he had this previous homestead, now he has a new homestead. But wait, you're still claiming homestead here. That's what the county bases himself on. So they will, in the cases of divorce, then separate you and treat you as two individuals who can claim their own homestead exemption. Okay. Acts that can affect your homestead exemption. So if you rent out the property in which you are claiming homestead, this goes to all my Hialeah efficiencies out there. If you have an efficiency in your home, if you have any part of your home rented, don't mean to pick on Hialeah, anywhere, that is considered that you're not, it could affect your homestead exemption. And trust me when I tell you, I have had clients that have come to me with a letter from the county that they now owe $20-something thousand in back taxes and in penalties because of this. And one of the main reasons that the county finds out is because you upset a neighbor. And the neighbor calls the county and says, oh, really? I'm going to rat you out because you're renting your house and you should not be renting your house. And now there's 20,000 cars parking in the driveway and they're parking on my grass and they're blocking my house and you've done nothing about it. So I'm going to call the county and report it. That is the number one reason. Another way that the county can find out, obviously, is through your tax returns. So if you are claiming any rent monies that you're receiving from a tenant and reporting it as income in your tax returns, guess what, people? They can subpoena and they can request copies of tax returns and look at it there. So there are multiple ways. I have had clients that come back to me freaking out because what will happen is they will then penalize you, fine you. They will retroactively go back to whatever year it is that they have proof that you've been renting part of the house for, or let's say if you don't even live in the house and you claim homestead, even more so, and they will remove the homestead, reassess what you should have paid in taxes, and calculate all of that. And that entire balance of penalties, fines, back taxes, reassessed taxes is all due in one payment to the county. And if you do not pay it, they can place a lien on your property and they can foreclose on that lien. So please, please, I beg of you, if you're on here as a homeowner, if you're on here as a realtor advising your clients, please do not mess around with fraudulently claiming homestead exemption in properties, because I have seen it on multiple occasions go bad, and the county will come back and reassess you, and then you're going to find yourself in a very difficult situation. So renting a property in which you are claiming as your homestead is a no-no. Benefiting from the resident-based tax exemption for 2 properties. You cannot. In Florida, you can only claim 1, because again, you can only live in one house as your primary residence. Okay. Same thing, assuming that married owners living separately. So if you say, oh yeah, buy a property in Broward. Oh, my husband owns a property in Broward. I own a property in Dade. And yeah, we're married. Oh, but we're going to say we're not. And my husband's going to put his driver's license with the property up in Broward. I'm going to keep my driver's license here. And we're going to claim that we're legally separate. That doesn't exist in Florida. There's no legal separation. That's not a legit marital status. So he can claim homestead allá and save some money on those taxes. And you're going to get busted, and they're going to find out, and you're going to be hit with large penalties and back taxes. Okay. Or not establishing your permanent residency by that January 1st. Okay. These are all ways that you cannot claim homestead and will be penalized for it. Another thing that can happen, and I actually had it happen recently to a client of mine, is that the father owned a piece of property. The father passed away. They did not inform the county. That was the father's homestead. So they continued on with the father's homestead on the property. They had the property rented out. Several years passed. And then the county somehow, whether they got through vital statistics, again, they have their ways of verifying, found out, wait a second, he passed away 5 years ago. So for 5 years, and she got hit with a large tax bill and penalties and fines. And my response to her was, you need to pay it, or the county's going to put a lien on your property. So this is the consequences of improperly claiming homestead. Owners will lose their accrued Save Our Homes portability. You are subject to back taxes for up to 10 years they can go, and a penalty equal to 50% of each year's unpaid taxes, plus interest at 50% per year until all taxes and penalties are paid. And the county's lien for back taxes is a super priority lien, which means they can foreclose on your property and take your property from you. Okay. So, and it will attach to any other properties that you own. If the property that they take back is not sufficient to liquidate, it's like having an outstanding judgment and debt against you. So there are severe penalties. So please. If you don't agree with the amount of your taxes, so a lot of times, taxes go up as far as the value of the homes go up. They're like, but wait a second, my taxes have jumped up. Why did they jump up so much? You can always try to appeal your taxes. Absolutely. It's appealed to what we call the VAB, the Value Adjustment Board. You can file your appeal, and maybe you don't agree with the assessed value that they put on your home. So, for example, if the county, you're assessed when you get your notice, a lot of times in September, you will get what we call the trim notice. So it's like an estimate of what your property taxes are going to be for that year. And let's say the county has the assessed value of your home at $1 million. But you're like, wait a second. The last couple of houses that have sold in my neighborhood have only sold for 700,000, 650. Maybe there was one that sold for 800,000, but not to that million value. You can always file a petition and you can appeal the taxes, and basically to prove to the county or appeal to the county that the value they're putting on your home is excessive. It's not what it really should be. Obviously, you're going to have to provide documentation. It is a process that is going to go through the Value Adjustment Board. You're going to have hearings and basically present your evidence, and then they'll take it into consideration. Now, here's the thing. Even while you're going through this process, you still have to pay whatever taxes were assessed to your property for that year. So the appeals for taxes are heard every year between August 24th and September 17th. If by September 17th, they have not reached a decision yet, and let's say because they have multiple appeals on filed, so they're behind, and let's say November comes around and it's still undecided, but your new tax bill came out, you can't say, oh, I'm not going to pay my property taxes because I have it under appeal. I'm going to wait until the appeal comes out. No, you have to pay your taxes, or if you have escrows with your mortgage company will pay the taxes. And then if you win that appeal, then the county will credit you back and they'll adjust your taxes. But you can't just not pay your taxes while that process is pending. So sometimes you are successful, and yes, I have had clients that have been successful in getting their assessed value of their home reduced because it truly was overassessed by the county. Other times they've come back and said, nope, that's exactly what it should have been. Or I've even had it other times where, you know what, we actually didn't assess it to the full amount. We've done our research and actually should have been assessed a little more. So if you are going to appeal your taxes, make sure you truly have your information correct, and that you do know what the value of your home is, and that you have proper documentation to show that it is less than what the county assessed it at, because you don't want to find yourself on the other end where it actually is like, well, actually should have been a little bit more. But you can do that, and it's through the Value Adjustment Board to try to appeal those taxes. So we've covered then our homestead exemption. When can you apply for it? Starting January 1st through March 1st. It has to be your primary residence. It has to be in your name. It can't be in a corporate entity. We touched a little bit on the tax benefit of homestead exemptions, where you get that $50,000 deduction off your assessed value. So let's say if your house is assessed at $500,000 minus 50, $450 is what you're going to pay taxes on that value. If you have the widow exemption, then it'll be that much less. And if you have the senior exemption, that much less. And those are the tax benefit. And then you have that 3% Save Our Homes cap from year to year to year. Those are all the tax benefits of the homestead here in Florida. Now we're going to talk about some of the other benefits for your homestead in Florida that deals with creditor protections, that deals with protections once you pass away, as far as passing down that creditor protection while you're living to your heirs. These are all valuable assets and valuable protections in the homestead property for Florida. One prime example, and as we get older now, I'm realizing some people might not understand this example, but I'm hoping still the majority of people do, that I give with the benefits of homestead protection on the creditor side is O.J. Simpson. So if most of you don't know, or if you do know who O.J. Simpson is, famous football player, he owned a house down here in Pinecrest, a beautiful mansion. He allegedly killed his wife, was acquitted for it. But he racked up the family of his late wife and the other gentleman that was murdered, sued him for civil damages. So from the criminal case, he was able to escape, but from the civil, they went after him for civil damages and they got a judgment against him. Well, he has his house down here. This all happened in California. He had his house down here in Pinecrest, and guess what? The state of Florida's Constitution protects our homestead against creditors. Creditors cannot force the sale of your homestead property to collect on a judgment. They cannot. It protects the roof over your head. So those creditors, that family, could not have him sell that beautiful mansion in Pinecrest in order for them to collect the money that he owed them. It's homestead, it's protected. So that's one of the very big benefits that we have here in the state of Florida. So protecting your homestead through estate planning. So as I mentioned, when we do our estate planning, when we do our probate, one of our largest assets that we have is our primary home. Yes, we might have also investment properties, but typically it's our homestead, our primary home. How do we protect it? So that it doesn't have to go through probate, so that it doesn't have to go be subject to creditor claims the day that you die, and then your heirs basically are left with nothing because they had to sell the house and pay off all these creditors. Well, there's various ways that we can protect your homestead. One is placing it into a revocable living trust. Putting your homestead into a revocable living trust keeps your home out of probate and ensures that it transfers over to your beneficiaries directly without having to go through probate and without being subject to creditor claims. Another way to safeguard it is by claiming that homestead exemption status on the property. That is key. Just calling it or just saying, oh, well, this is my homestead because it's where I live. If you don't file that exemption for the taxes and declare it with the county, your homestead, it does not matter. And believe it or not, there are many, many people that forget to do it, don't know about it. That's why I love to inform and educate people, or they never got around to it. And then all of a sudden it's been 2-3 years and they never claimed the homestead. One, you lost all those tax benefits and then you can't go back. So if you didn't apply on time, you can't go to the county. Oh, but county, I bought this house in 2020 and I've lived in it. Look, here's been my license, my electricity bills, everything since the day I bought it. As the county doesn't care. You didn't apply. It starts from the moment you apply. They will not retroactively give you homestead. So it's very important to make that claim and file that exemption. Also, on your homestead, if you have that joint tenancy and on any property, your joint tenancy with right of survivorship automatically transfers to that co-owner upon death. Another tool that we use a lot for our estate planning, the enhanced life estate deeds. Those also avoid probate and allows you while you're alive, that is your property, you can claim your homestead exemption. It does not affect your homestead, and then once you die, it passes to the person that you named on that deed as the remainder. There, I will say, once you pass away, when that person inherits the property, the taxes are going to be reassessed because your homestead dies with you. Like I mentioned earlier, you can't inherit that. You inherit the protection from creditors, but you don't inherit the tax benefit. So that new person that inherits, they're going to have to apply for their own homestead exemption. Okay. Also for long-term care planning, this is so important. I'll have people who are getting into those older years and want to apply, and they qualify for Medicaid. Medicaid has some very strict guidelines to be able to qualify. One of the exemptions, as far as like the guidelines, are as to how much income or assets you can own to be able to still qualify for Medicaid. But an exemption is your homestead. They will not take your homestead into consideration as the value wise for you to be able to qualify for Medicaid. So again, there are so many benefits to claiming that homestead exemption on your property besides just the tax benefit. Okay, so there are strategies to protect your homestead from Medicaid recovery, and even while you're living, to be able to qualify for Medicaid even though you own a property, as long as it's your homestead. You need to make sure that your ownership structure aligns with your estate plan. So to protect your homestead through estate planning, is title held as husband and wife, or is it only held in the husband's name or only in the wife's name? If that's the case, then we need to figure things out, because when that person passes away, it's not going to automatically pass to the wife if she's not on title. It's going to have to go through probate, unless it's in a trust or an other estate planning vehicle that will avoid probate. Also, make sure for estate planning to regularly update any beneficiaries on any deed designation. So ladybird deeds. If you did a ladybird deed and you named a beneficiary on there, let's say it's your daughter and your son, and heaven forbid one of them were to pass, you need to update that deed. That's one of the, I'd say, limitations with a ladybird deed. In a trust, you don't have to do that. The trust will automatically have language of what happens if one of your children passes. A ladybird deed doesn't. So it's very important to know that. I had a client recently as well that her daughter passed. She did a ladybird deed, so we had to amend it to remove her daughter. And she wanted to put her granddaughter, who was already an adult, on the title instead of the daughter. But we had to change that, because if we didn't change it and the lady passed away, then it would go to the estate of that daughter. And we would be back in probate, which is what we want to avoid. Work with professionals, make sure you understand, and people who know this, and regularly update your plan, life changes, marriage, anything like that. Step-up basis for estate planning. This is another advantage you have with the homestead, is that you inherit this step-up basis from your parents or anyone you're going to inherit. So if your parents buy a home for $100,000 and they maintain it as their homestead, they keep it as their homestead, and then they pass away and the property passes to you, and at the time that they pass, the house is worth $400,000, that $300,000 of equity is a gift. It is not taxable. It's called the step-up basis. You inherit it. Now, if you keep that property and you decide to rent it and then you sell it for $450,000, then you'll owe capital gains on the $50,000, what you appreciated. But what it appreciated during your parents' lifetime, you will not pay taxes. Again, another benefit of these homestead exemptions. So I know we're getting to a little bit about a minute over, and I want to address some of the questions real quick. So why does the homestead matter? I hope I've explained that clear. You have tax savings, significant tax savings with that Save Our Homes, the $50,000 reduction, as well as the other reductions on your property. Also, you have the creditor protection. It applies to your real estate, your primary home. The step-up basis does not apply to gifts. That doesn't apply to any gifts. So if you're gifting someone a property during your lifetime, the step-up basis would not apply. Okay, so this is. So I want to take a minute, go through, and let me scroll back and see what questions we have here. What happens when originally there were 3 owners, 2 have died, and the one left original owner was not part of the original homestead, but only on the deed and the mortgage? Well, your taxes are going to get reassessed. So when those 2, and it depends. Did they own it as joint tenants with rights of survivorship? If that's the case, then the title automatically goes to that last owner. But if he did not have homestead, taxes are going to get reassessed. They're going to go up because those 2 people that passed away, their homestead and their Save Our Homes passed with them. So that new owner is going to have to apply for their own homestead, and they're going to then start that save our homes from when they apply, and then that's when the 3% cap will start. But the value of the house will get reassessed at the current value when they apply for it. To remember that there was none in, okay. Okay, so I think I answered that. Let's see. You're very welcome. Regarding renting, does the statute give a minimum or maximum amount of time they can rent without affecting the homes? Example, 6 months rental max, or an Airbnb. An Airbnb cannot be your primary residence. If you're renting Airbnb, any portion that you're renting of the home takes it away from that home being your primary residence. Airbnbs cannot be primary residence. Doesn't matter if you live in it 6 months and you rent it 6 months. It's not it does not qualify. Once you're generating income and having it as a rental, it cannot qualify as your homestead property. My husband and I sold our house June of 2023 after living there since June of 2020. Then 10 months ago, he left me and rented an apartment in Hollywood. I'm living in a rent house now, but I'm buying a house on my own in Melbourne, Florida. Can I apply for homestead in my new house? Yes, you can apply. Can you transfer your homestead from the house we sold? If you sold it in 2023, no, because you have a gap. So you had it in 2023, you did not apply for 2024, you did not apply for 2025, so you lost that ability to port it. When you port, it has to be from a previous year to the next year. There can't be a gap of time. So you can apply, yes, you can apply for your new homestead, but you're not going to be able to port it. You can try to fight it, you can try to appeal, you can try to state that it was as of a result of a divorce and try and see, but I truly doubt that the county's gonna allow it. But you can try. What's the worst? They say no. If they say yes, then wonderful. But typically when there's a gap of time, they won't. It has to be porting it from 1 year to the next. If I did a ladybird deed to my daughter, who will be the next property owner when I pass away and she lives the property, would she receive the protection exactly as I have it now? No, unfortunately not. So once you pass away and the property legally transfers over to her, the property is going to get reassessed. You're going to lose your homestead, your save our home and everything. Property is going to get reassessed at whatever the current market value. But then if she's going to live the property, she can then apply for homestead, and then she can apply to have that 3% save our home cap on that property going forward. But unfortunately, it does not pass from a parent to a child. It would pass from a spouse to a surviving spouse. So if you have a situation, where the property was in the spouse's name only, not in husband and wife, which don't even get me started on that. That's a whole different webinar, why that should not be. But anyway, if it was in the spouse's name and for whatever reason you were not on the title and your spouse passes away and you inherit the property 100%, you could, with that order from the probate court, when you apply for your homestead and your widow exemption, you can inherit your spouse's portability because the two of you live there as your homestead, but that does not transfer to a child. So her taxes will get reassessed, but then she can apply for her own homestead and her own save our homes cap. And do you have to apply yearly for the homestead exemption or just one time? Just one time, but every year. So the very first time you apply, you have to fill out the application and it gets approved. Every year at the beginning of the year, you'll get a notice from the county saying, hey, you have homestead on this. Do you still own this property? Is this still your homestead? If it is, you don't have to do anything. It'll automatically renew. It'll also ask you in the paper is, do you qualify for any additional exemptions? Maybe when you applied, maybe since then you're now a widow. So now you can apply for the widow exemption, or the senior exemption. Then you can add on those exemptions, but you only have to apply for the homestead one time and it renews every year so long as you own that property. Now, if let's say in 2024, you sold that house and you're renting now, so you're not going to claim a homestead anywhere, and you get that little paper saying, hey, do you still, just mark it back, say, no, I sold it, and mail it back. Okay. But you do not have to apply every year. Can the owner of a condo receive homestead benefit if it's absolutely condo, townhouse, single family home? Absolutely. It does not apply to commercial properties. It does not apply to properties that are held in the name of a corporation or investment properties. But condo, townhouse, single family residence, yes, you can apply for your homestead exemption. I did a quitclaim deed when my daughter turned 21. Is she okay? She's 40 now and won't be living in it. She is on the tax bill. Okay. For this, I would need a little bit more information to get an idea of what your concern is. Feel free, you have my information. If you want to shoot me an email with your property address and specifically like a little bit more detail what your question is, I'd be happy to take a look at it. If you added your daughter to the title, that's what I'm assuming you're referring to, when she turned 21, then she is an owner with you on the property. She does not have to claim homestead. If she claims homestead somewhere else, she can claim her homestead somewhere else. She does not have to claim it on your house. You would be able to claim the homestead. Now, the only thing that I would not have advised putting her on the title unless there was a specific reason is because now she lost that step up basis when you pass away as far as the capital gains taxes. But I'm not sure if that's the concern you have or the question. But if she's on title with you, she does not have to claim homestead, and she should not claim homestead if it's not her homestead, but she can still be on the title with you. That's fine. I'm living in my homestead property, but I'm remodeling another home to move in. Would I qualify for the portability of the homestead exemption? Yes, you would. Yes, you would. Once you port and transfer over to that home, you would be able to port it over. Yes, you would. If my father quitclaims the property to me, but he still lives there, will he lose the exemption? Yes, he will. Anytime if he transfers over the property to you, and even though he's still living there, but the title is legally over to your name, he will no longer be able to claim homestead exemption or any of his other exemptions. It will now be under your name, and you have to claim your own homestead. Again, I don't know why you would want to do that. I would definitely suggest you give me a call. If the concern is, well, if something happens to my dad and he dies, a quitclaim deed is not the answer. There's other ways, ladybird deed, revocable living trusts, because that'll protect you and that step up basis, and it'll protect his taxes, it'll protect his homestead, it'll protect all of that. So a lot of times when I get clients that call me and say, oh, I want to add my child to the title, I want to do a quitclaim deed, my first question always is why? And if it's, oh, because if something happens to me, I want them to get the house, my answer is always no. A quitclaim deed is not what you want to do. There's other ways to do it, because with a quitclaim deed, you're going to reassess taxes, affect the homestead, affect that 3% cap, affect the step up basis for capital gains when your daughter inherits that property and you pass away. So please, 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 please speak to an attorney who specializes in real estate law and estate planning, and who knows all the effects of what can happen the day you die, what can happen now, and really understands this and can guide you and give you the best answer. Because I've seen people go online and they find quitclaim deeds and they Google it, they download, they file it, and then later when they come to me, but why and this, why did this happen? And I tell them, because you did this and you shouldn't have. That's not, and then, oh, well, let's fix it. I'm going to give it back to him. Doesn't matter. What's done is done. So yeah, please. So if your legal status has changed since you bought your house, can you apply for a homestead exemption as a resident now? Yes, you can. So you can apply. So let's say you bought the house and you weren't a permanent resident, right? And now you are. It's been 5 years. That's fine. Your homestead starts as of the day you qualify. So you can't go back and ask for the homestead to apply to all those 5 years before, but you can apply now. Okay. You don't apply for homestead isn't only when you buy the house. Obviously that's the best time to do it, but you can do it anytime when your status changes. If I transfer my house to a revocable trust to my daughter as the beneficiary, get the step up basis? Yes, they do. Absolutely. If you put it into the trust, that's also one of the major advantages. They retain that step up basis. Do you know how much is the additional homestead discount for seniors? I believe seniors is $500 off the assessed value. So let's say if you have a property that's worth $250 and then you have minus, it's assessed. The assessed value is 250, minus 50,000 for the homestead, minus 500 for the senior. You're going to be paying taxes on 100 and whatever the math is. 250 minus 50 is 200, minus 500, 199,500. Okay. So it's 500, and I believe the widow is 5,000. The tax collector's website, when you go to apply, you Google it, it'll give you every exemption, what the qualifications are to meet it, and what the value is that they reduce. So I hope you have found this video. I apologize, we went over on some time, but you guys had some great questions. So I wanted to make sure I answered them. If you have any other questions, you want to speak with me, meet with me, talk about estate planning and protecting your homestead and setting all that up the correct way, please feel free, reach out to us. Also, anything else that follow our social medias. We constantly are putting out videos and holding these webinars on different topics to inform everyone. So stay tuned, follow us on the social media at Nunez Law Florida, and that way we can go ahead and keep you informed, and we're always here to help you. Thank you very much for joining us, and until the next time, I'll see you then.